This matter comes before the court at this time for further proceedings and initial proceedings regarding a motion to modify parenting time that was filed by Mr. Vorns on June the 16th, 2025. I'm not aware if there has been any type of formal response, Mr. Bell. I'm not aware of it or its contents. Has such a document been filed?
We filed a proposed parenting plan, but not a response motion.
All right. When was your proposed parenting plan submitted?
We submitted it yesterday.
Okay. Well, that's why I don't have it.
Judge, I can email that to you.
Please do. All right, Mr. Bell, then summarize for me. If you're proposing in return some sort of a proposed parenting plan, what are you suggesting?
Oh, we just want to remain with the same parenting plan that they've had.
All right.
His motion isn't a motion to modify parenting time. It's actually a motion to change legal custody and residential custody, even though it's titled motion to modify parenting time. So
I would concur with that assessment, Mr.
yes.
Bell.
And my whole thing is I didn't file a response motion because I don't think it even meets a prima facie case in this particular situation. They previously had an agreed order, and that was done in April of this year. He filed this motion 2 months later, and basically when he did the motion in April, these facts were all the same facts that existed at the same time. I think res judicata plays into the fact that these were all issues he could have brought up at the time, which he chose not to bring up. And once they entered into that agreement, that was in the best interest of the minor child at that time. And I don't think anything has changed in regards to that being in the best interest of the minor child. So I don't think anything has changed that would warrant changing custody in this particular case, because there's nothing that's changed from the last time they were in court. All these facts were available at the time. There was nothing in the proposed parenting plan and an order that was submitted to the court and approved by the court that indicated that Mr. Isaacs could not be around the minor child. So without that, I don't think that they have met the burden of best interest and no prima facie case to proceed.
Very well. I understand your position, Mr. Bell. Mr. Vorns, do you have anything you want to say in response?
I would say that there was some pushback that is in the parenting plan that I proposed that goes back and forth with me and Mrs. Isaac having a conversation. I was under the impression that she was removed from that situation, that our daughter was removed from that situation. She reiterated that she wasn't, trying to move back or anything like that, that she wanted to be from that situation. And then Mr. Isaacs just kind of got integrated back in. I didn't have any idea. I had no idea. She didn't talk to me or anything. So once again, my impression was that she had removed herself and our daughter from the situation, which is why I changed the parenting plan from the beginning. Because I'm like, okay, you're showing me that you're moving from that situation, that you're looking out, like obviously our daughter is in your interest. So that was something where me and her had that conversation where I was like, okay, I think we can move forward going this route. And then after I filed that, that is when those other instances that I put in the write-up that came to light, which is what forced me to do this.
All right. You didn't anticipate that they would reconcile, in other words.
At all. And she kind of like, once again, kind of reiterated that she wasn't looking forward to that. And then, a few months or a month later, she would kind of hint like, hey, how would you feel about it? And then she would hint it again, how would you feel about it? And I just kind of told her where my stance was on it from the beginning, that it hadn't changed.
I would let the court know factually they don't live together. Mr. Isaacs lives in South Wichita. My client lives in El Dorado. And the facts that he's proposed in his motion, Mr. Isaacs, the situation with the holding a gun to his head did not occur. He's been in therapy for that situation. That's why I'm here. If we have some sort of evidentiary hearing on this motion to explain that they do not live together. They do have contact with each other, but they do not reside together.
All right. Thank you, Mr. Bell. Did this child complete the year of school in which she was disrupted from her Oklahoma school district and then moved to El Dorado Middle School very late in second semester? Did she complete that year?
Yes, she did. Yes.
Chelsea, will you verify that for me?
Yes, she did.
Okay, so she advanced to what grade?
She will be in 7th grade.
So she'll be again at El Dorado Middle School.
She's going to Circle because we're in Circle District.
Did you move?
I didn't move. I live in El Dorado, but I'm in Circle District.
Okay,
Yeah,
but yet you enrolled her in El Dorado Middle School last year.
correct. Her brother was at El Dorado Middle School, and she wanted to go where he was at, or high school.
All right.
If
So
you-
what's different now?
It's just a district thing. We're keeping them in the district. And we feel that Circle's a better school district as well for them.
All right. Obviously, the court doesn't support a child being moved around from school to school. I
Correct.
think school stability is an important concept, which I'm certainly going to make an order on here today. There was some mention in Mr. Vorn's motion of a conversation between he and Chelsea, where Chelsea, you represented to him that there was doctor's documentation and
Mhm,
he was not a threat to himself,
correct.
despite his holding a gun to his head and threatening.
He did
apparently
not,
given the
he did
impression.
not, he did not hold a gun to his head.
All right.
Yeah.
Well, the court has seen that very stunt pulled in a couple of different circumstances. One, a person who has severe mental health issues, which constitutes a threat and perhaps not only to himself, but also others around him. The other scenario where the court has seen this is that it's a dramatic acting out behavior to gain some sort of advantage or to make somebody give them sympathy or influence them in some way. And I don't know if it happened, though there's certainly a suggestion here that it did. Then if there is some doctor's documentation that regardless of what did or didn't happen, he's not a current threat to himself, then this should be turned over to Mr. Vorns. And I trust it does exist, Chelsea.
Yes. I offered that to him.
Okay, did you turn it over to him?
He didn't want it.
Well, the court wants to see it.
Okay, we have that
And when
documentation.
you provide it to the court, you can do that through an email to my assistant if you so choose. I want
Okay,
it to go to Mr. Vorns as well.
okay,
I think that will, at least to some degree, address some of his ongoing concern. The court has reviewed what is essentially just a motion supported by a whole series of communications between Mr. Vorns and Chelsea Isaacs regarding this purported incident which took place involving Joel Isaacs, a gun being held to his head. Hardly a short and concise statement of facts here, Mr. Vorns, but the court's read it. And the court agrees with the assessment of Mr. Bell. This court has an obligation to look over a motion to change custody, which this is. It's not a motion just to modify parenting plan or visitation time. This is truly, you're modifying the very core of custody in this case and made a request essentially for sole custody. And in other words, shutting Chelsea out of decision-making for this child. Your motion does not meet a statutory test. It must establish sufficient facts to establish a prima facie case that would warrant a change of custody. Your motion does not. So the court will take no further action on the motion to change custody in this case that Mr. Vorns has submitted. But with that said, and this matter currently before the court with notice to both parties, certain additional orders are called for here. Again, the first one is that Chelsea Isaacs is required to provide documentation of the doctor's clearance of Joel's mental condition regarding him not being a threat to himself or others to this court and Mr. Vorns within 7 days of today's date. Is there any reason, Chelsea, that you see that you can't comply with that?
No, sir.
All right.
Your Honor, if she can email that to me, I'll email it to both parties. Can you do that to me today? Okay.
That is acceptable procedure, Mr. Bell. Further, there needs to be some stability established for your child's educational program. Yet again, she's going to have a change of schools to the Circle School District at the start of this school year. Your thoughts on that, Mr. Vorns?
It's a little frustrating for me being a teacher, me and my wife being a teacher, and understanding that she hasn't been tested since 5th grade. I'm worried that she's not going to be able to be where she needs to be educationally, because we don't even know what accommodations she's going to need because she hasn't been tested. We are at a school where it is going to be easy for us to get her tested and get everything that she needs. So I was just frustrated because
Why does she need testing, Mr. Vorns?
just as far as like, because she is on, I guess she is ADHD, so she is in she is in lower classes. And so the testing kind of gauges her progress through the year to see, hey, let's move her to these classes instead of keeping her where she's at. And she hasn't been able to be tested since 5th grade, which is going to be a problem if she's in 7th grade now. And we still don't know exactly where she needs to be. And she's had a cutoff where she's just missed so much school that she hasn't been able to be tested. And that's a worry for me.
Well, Mr. Vorns, couldn't you, as her father, work with the Circle School District and its counseling staff to request such testing be done at this stage?
I mean, I guess I could get in contact with them. I didn't even know that she was going to Circle for sure. Once again, she was in El Dorado. And once again, like I said, that was something that I was worried about when she originally moved, and why she wouldn't come with her father and her mom, which is a teacher, which is in a school district who has those resources that we can get her tested and get all of this handled so we know what she's going to need to be successful.
Mm-hmm. Understood.
May-
Go ahead.
That is false. She was tested in Broken Arrow in 6th grade multiple times. They saw improvement with her when she moved down here. Their testing dates are different from Oklahoma to Kansas. So she did test in 6th grade. The way they did it in El Dorado School District is they kept her with where she was at based on her testing she was not diagnosed with ADHD until the end of 5th grade year. We took every step that we needed to get her tested. We did everything. I took her to doctors, behavioral health to get medication that she needed. She has been very well taken care of in that department. They will retest at the beginning of the school year. That is not a concern at all. They do that with each school district. So she will be retested within probably the first month, is what it sounds like with schools. So, and that's every district.
Well, the court will order that Mr. Vorns have full access to the child's educational records.
Which should never been a thing he couldn't do. That was never the case.
All right. I want to
I
make it
wasn't
clear
on
that he has access.
any contact information I was just listed. I wasn't listed to get any type of that information because my kids are all in a program, like they're in a power school setting. So if anything happens, we get notification immediately. So if they're missing a class, if they're late, tardy, anything comes in, we get notified immediately. And that's something
Chelsea,
I haven't been on.
All right.
Just-
You have full access to your child's educational program and records at all times, Mr. Vorns.
All he had to do was ask. That would have been a request that could have been fulfilled.
And if you're not satisfied with the statements regarding testing for your child, again, I encourage you, Mr. Vorns, to work with the Circle School District to request such testing be conducted for the reasons that you've stated.
Oh, I certainly will. Thank you.
Right. Further, no more moves. I mean, this is the way the court sees it. Both parents are fit and proper parents. There's no parent that has a vested right to primary custody or residential school custody. The court will restrict the mother from enrolling or having this child participate in school services for the 2025-2026 school year, it must be in the Circle School District schools and no other. I can't restrict you, Chelsea, from moving, but if you move, the implication will be that you drop off your child with Dion, then he can place her in whatever school district at that point he deems to be appropriate. So I know that would have the effect, perhaps, of a effective change of custody, but it really is just recognizing you have joint custody now, and that the court is going to restrict any more movement of her from an educational program. So if you want to enroll her in Circle School District as a resident of that district, the court will approve it for the 2025-26 school year, but no more moving her around. And the court will only approve traditional school attendance. If there's any alternative programs, such as online schooling and some of the alternatives which are currently being chosen, both parents have to agree on that alternative, or it doesn't happen. That's something that should be a joint custody decision if any alternative program is contemplated. So the court will place that residency restriction really until further order of the court. But certainly the court intends for that to be fully in effect for this next school year. I don't want any more during school year changes of school or residency for this child as to what happened last year. Mr. Bell, I know that you've been taking notes feverishly as the court has spoken. I am
Yes.
going to ask you to draft an order stemming from today's proceedings, setting forth the various rulings that the court has made.
Yes, Your Honor.
So there have been some slight amendments to existing orders made by the court here today, but the court will not take any further action on the motion to modify parenting time, as it doesn't meet the statutory test of establishment of a prima facie case, as related by the court earlier. I do understand all your concerns here, though, Mr. Vorns. You're just being a good dad, but it doesn't warrant the type of dramatic relief that your motion sought here. I also wanted to make the statement that I do believe that Chelsea did take appropriate corrective action when this whole domestic disturbance took place, because she separated her and her child from that situation, at least for a period of time.
I agree.
Which I believe is a responsible act on her part.
I agree.
So I give her some credit for that as well. And just hope that there's nothing like that in the future that she has to move the child from.
Now, I guess my question, so if Mr. Isaacs is, I guess, at her residence the majority of the time, and what can I do just to ensure the safety of our child, just in that situation? Because although, yes, he is not physically residing there, he is there majority of the time. Anytime I've picked up my child, he's there. So,
Aren't they married?
yes.
I'm not going to get involved in separation of married persons. I hope that Chelsea just manages that situation in a responsible manner, not only for herself, but for the child that lives primarily in her home. And I'm also presupposing, Mr. Vorns, that there is medical support for the fact that he's not a threat. And in fact, the court's not going to authorize him to live in the same home as the child until that medical evidence is turned over, which I put a very short time frame on. All right, Mr. Isaacs, though you're not a party here, you had something you wanted to say when you unmute yourself?
Yes, sir. Thank you for allowing me to ask a question. When you were talking about moving, Jordan will need to stay in Circle School District. If Chelsea were to move homes within that district and not interrupt school. Okay, that's what I assumed, but I wanted to confirm. Thank you, sir.
She has the freedom to move within the district.
Thank you, Your Honor.
Again, I do worry about transients and not staying in one place. That's not necessarily good for a child either, but if you had a chance to upgrade your home or had some great opportunity within the district to move, I'm not going to preclude you from that, because that's not going to do anything to disrupt the child's educational program. But I hope it would constitute an upgrade in some way that would benefit the child as well as yourselves. But no, it doesn't restrict within district movement, but only out of district relocation. Again, the whole point is stability for the child, especially educational stability. All right. Do you need any further clarification regarding the court's orders made here today, Mr. Bell?
No, Your Honor.
All right. Mr. Vorns, do you have any questions about the court's orders?
Not at the moment, no.
All right, very well. Mr. Bell, if you'll then send your proposed order to Mr. Vorns, obviously we'll need to seek his approval of the document. Mr. Vorns, even if you don't agree on everything that the court has ordered, if Mr. Bell's journal entry reflects what the court ordered, you should approve it and get it back to him as soon as possible. All right. Very well. Good luck to everyone to working together for this child's best interest in the future. If there's nothing further at this time, this matter will currently be in recess, and this meeting may be ended for all at this time.
Thank you.